Okay, everybody's good afternoon, everybody, and again, welcome to today's webinar, number 13, I think, in our series, which is fantastic. My name is Craig Vaughn. I'm the president of Castle. I want to welcome everybody who is rejoining us this afternoon, and all new webinar participants. We have a good topic this week, phase 3, and our webinar count, our participant count is way up, which is exciting. We're going to do some polling for those who are listening. We're going to do some polling again. I want to find out what your neighbors are doing in response to that phase 3 designation. That seems to be the question that was asked the most in the pre-registrations. I would ask you to respond quickly out there so that we can move on to the results and the next questions. Marinez, can we start with question number 1 like we always do, just to see who's in the audience? So if you could post poll question number 1. I want to welcome back Michael and Jeff. The band is back together, so to speak. Jeff and I were off last week. Michael, we did watch your webinar. It wasn't very good. So I'm sure you're happy to see us back.
I suggest the attendees and the feedback we got beg to differ.
But guys, welcome back.
Welcome back to you too.
Thank you very much. We are going to go through a bunch of stuff today, but before we do that, I wanted to remind everybody that Michael and Jeff are here to offer their opinions. It's not legal advice for your association. For that advice, go to your association's attorney directly. I will say, I did watch a recent debate, and I'm a little worried about moderating this one because you two can get a little off kilter. So I remember the presidential debate. So I took some lessons from the moderator, and I hope you guys follow all the rules this week. So thank you for doing that.
When should we start interrupting now?
Listen, Jeff, will you take a second to introduce the firm?
Sure, I would be happy to. For those that don't know, K. Bender Rembaum is a law firm specializing in the representation of Florida's community associations and developers on occasion, and occasionally unit owner claims as well. In fact, we represent well over 1,200 associations. We're comprised of 19 lawyers, 8 of whom are board certified experts in this body of law. When you come to K. Bender Rembaum, it's not as though you're coming to a law firm that has interest in other multiple bodies of law. We are a straight, tried and true community association law firm. It's what we do, all the lawyers here, day in and day out. We have offices in Broward County, Palm Beach County, Hillsborough County, as well as by appointment in Miami-Dade. We are known for publishing many publications. My partner, Robert Kay, publishes Legal Morsels. I publish Rembaum's Association Roundup, the community association news you can use. We have radio shows going with Robert Kay and Peter Mullengarden, numerous webinars and a whole variety of association subjects of interest. And we'll be at the trade shows as those start coming back online, and doing our seminars live and in person once it's safe to do so again.
Michael, did he miss anything? And I think he got everything, but I'll give you one.
The only thing I would add on is the part about legislation, because I think that we're in session. We're about to move into 2021 session, which starts next year, and we are very active in that regard. Sean Brown, Allison Hertz are very active with the Florida Bar Subcommittee, the Condominium and Plan Development Subcommittee, and I happen to be the legislative chair for Florida Legislative Alliance. We actively work with a lobbyist in Tallahassee, protecting associations and trying to pass good law. So that's active and ongoing. It's something else our firm is very involved in. And as Jeff just added, which I appreciate, the expos are back. And so there is an expo in Palm Beach County on the 20th at the West Palm Beach Convention Center, and then on the 27th at Broward at the Signature Grand. And we will be there, I'll be there, masked and otherwise, and we'll also be doing some remote classes. So that's good to know.
Excellent.
Right, what kind of partner would I be if I didn't leave something for Michael in the introduction?
Exactly right. Exactly right. Well, listen, guys, on September 29th at 5 p.m., the governor surprised many of us by moving us into phase 3 of his reopening plan. As I recall, in South Florida, we were just figuring out phase 2. So it did come right on the heels of us just kind of learning what we're going to do in phase 2. So our focus today is going to be on the impact of this announcement on the operations for community associations. Quick look at the agenda. Phase 3, what does it really mean? We're going to talk about that. Current statewide order update and impact on community associations. We're going to focus on the Tri-County area But I will say the issues that Tri-County area is experiencing are going to be the same throughout the state. So there's great lessons in that discussion. And then if we get an opportunity, we'll do some specific Q&A. Please chat in your questions. I'll try and work those into the discussion this afternoon. So Marinez, before we jump into what phase 3 really means, can you show us who's attending today? So, wow, 2/3 condo and co-op and 1/3 HOAs, with half of those being our 55 and better communities. So a great range of associations. So thank you very much for that. Guys, let's talk about phase 3. Let's get right into it. We still have our executive order declaring that we're in a state of emergency, set to expire on November 3rd. We will have one webinar before that happens. So we can talk specifically at that time about the impact on associations. We're in phase 3 of the governor's reopening plan for the state. You know, the new phase 3 designation, as I understand it, deals with rules regarding the opening of businesses and really doesn't specifically in itself address operations of community associations. What does impact the community associations is the cascading effect of that designation on the counties and the municipalities and what they've done with their local orders. Oh, we lost Jeff. What they've done with their local orders. So,
I didn't do that.
we're going to focus on. We are going to focus on Palm Beach and Broward, Miami-Dade, as I talk to you and everybody in the introduction. But there are great lessons for everyone here. So, Ness, before we get into the discussion, I wanted to pose poll question number 2 for those in an HOA. Have you opened your pool, gym, and clubhouse? So we're going to see where people are, and then we're going to talk about whether or not you've made any changes. Jeff, we have you back. Can you hear us?
I just finished the Palm Beach wrap up, Jeff. Thank you.
I appreciate that. Thank you, everybody. Yeah, we lost power up here. Everything just went dark. I went on my cell phone, power came back on, but our systems are just rebooting right now. So I put you on my cell phone for a moment.
Look at you. Very quick. Good.
Very good. And so, Nez, let's stop that, and then I don't want to share it yet, but let's ask the same questions for condos and co-ops, and we'll come back and visit those answers later. So, for co-ops and condos, have you opened your pool, gym, and clubhouse? And I'm going to compare those to what we saw a month ago and just see what's going on out there. So guys, let's get to the meat of this discussion. Jeff, I'd like to start in Palm Beach. What regulations, restrictions are left standing? What's going on up there?
Well, there really isn't much left. All orders, save one, have been repealed by Palm Beach County. So the order that remains in play is facial covering, and that is a full bore requirement. We'll talk more about that and what that means. Social distancing is still required, and finally, enhanced cleaning protocols are required, and we can drill into that and talk about that as well. So we went into phase 3 on September 29th around 5:00 p.m. The mask order is set right now to sunset on October 22nd, though I think it's a foregone conclusion that that mask order will be extended. And then we have, of course, the emergency order from the governor, which is due to expire on November 3rd, and more likely than not, that will continue as well. So, recapping, Palm Beach County, 4 things you need to take away. All prior orders repealed except for, number 2, facial coverings required. Remember to do your social distancing, and enhanced cleaning protocols, which we'll talk about, I'm sure, as we go deeper into today's session. When it comes to swimming pools and amenities and such, social distancing is still required. However, the CDC does not recommend wearing a mask in the pool. So please be sure that if you're in the pool, you need to still social distance if you're not with somebody from your own household. As to signage, there is no signage requirement, but I think community associations are well served by having signage, something like we used to have than when it was required, so that if you're using the amenity, you're using it at your own risk. And a reminder for social distancing as well is a good thing to put into that signage. So that's a real quick Palm Beach County recap of where things stand today. Craig, any specific questions you'd like answered beyond that?
Lots of questions on monitoring. So the requirement to monitor is no longer there, notwithstanding the fact that it may be a best practice. but the
Well,
absolute.
it is, except here. Let me read directly from the facial covering order. This is from order 2020-028, and it's item number 4 toward the bottom of facial coverings. And it says this: a business or establishment's failure to ensure said compliance may result in fines, penalties, and/or other enforcement measures. So really what we're seeing then is the business or establishment, in this case the association, is still required to ensure compliance, but ensure compliance with what? Ensure compliance with folks wearing their facial masks. So if you can't do that, then in fact, I think you have to consider not opening the amenity.
Okay. And we're going to talk about some best practices later, but so are we, there's some questions coming in. Let's get to Michael's update on Broward and Miami-Dade, and then we'll start to circle back with some of the questions people are asking.
Sounds good. Maybe I can log in by then too.
Yeah. Michael, do you want to give us an update on the Broward situation?
Sure. Oh, now we're seeing 2 Jeff. Aren't we lucky? Okay, yes. Well, first, I want to say that in Jeff's summary, he made a couple of comments which do apply universally with regard to CDC requirements. All counties, and this is the entire state. And I know we have a bunch of listeners outside of the Tri-County area. This is statewide, those CDC guidelines with regard to sanitizing, with regard to social distancing, that does remain in place in the entire state. Broward County, if we're talking specific about the Tri-County area, Broward County is the only county that, to our knowledge, that has come out with very specific further orders since phase 2. Broward County came out with an order 25, which, again, and Craig, you correctly pointed out, was really focused on opening up of business establishments, restaurants, bars, and pubs in particular. Then 26 had to come out because governor issued an order that said, hey, this is how we're doing this, phase 3. And also said you can't fine individuals if they're not wearing their facial coverings. So then Broward County on Friday the 2nd came out with order 27, and that's the order we're going to focus on here right now. And the order focuses on facial coverings, but also does summarize the amenities. So I just want to get to the amenities first. When you're talking in Broward County about community rooms, fitness centers, and gyms and housing developments, this particular language remains, and I think it's important, and I personally believe it applies across statewide. No community room, fitness center, or gym is required to be opened if the housing development does not wish to do so or believes it cannot do so safely and in full compliance with the requirements of this emergency order. Any decision by a particular housing development is also subject to any applicable internal rules or regulations of that entity, in this case the association, and housing developments may impose more stringent restrictions beyond those required by the Broward County order. That phrase applies to all counties, by the way, but it's specifically in this order, and I think that's very helpful for us to understand. And like you said, we'll get into best practices a little later. With regard to gyms, fitness centers, community rooms, Broward does have the 50% occupancy still in place. Social distancing requirements don't apply to members of the same household, but maximum 50% occupancy. The community rooms and fitness centers and gyms are now able to be extended to not only residents, but their family members and guests. If the board wants to limit that, they must do so by rule. The order does permit them to be open to guests as well as non-resident family members. If you want to rent out your community room, use it as a party room again like you used to, that is also now permitted, but the order has something that's attachment 20, which has to do with function rooms, social functions, and it's geared towards those halls like the Signature Grand, but that is what you need to follow if you want to extend your room to have used as a function space for party events and such, where you're going to have outside people as well. The 6 feet social distancing and CDC guidelines must be adhered to, and you can play multiplayer games in the community room with people in the same household, but everybody has to be wearing facial coverings. Okay? With regard to the pool, and I'm going to extend on the facial coverings, I'm going to conclude with that because that's really, I want to get very clear on that. With pools and with the pools, again, with pools, 50% capacity still in place in Broward, pools and pool decks, though, are now also extended to not only residents, to the non-resident families and guests. So those limitations against guests being restricted is out in the Broward County order. Your 6 feet social distancing, your CDC guidelines must be adhered to. And now the monitoring has been pulled. That either or option in Broward is pulled. So now it's as far as if you you could have removed your furniture or left your furniture and then had to do these things. Now what it says is the housing development must ensure that pool chairs, railings, gates, tables, showers, and other equipment at the pool and pool deck are sanitized on a regular basis. So having a monitor isn't necessary, but as Jeff pointed out earlier with regard to Palm Beach, like I said, applies across the board. These sanitization requirements are something that is the obligation of these associations. And so however you can best do that, whether that's regular monitoring, whether that's a walkthrough every hour, that's something to be discussed with your management team and figure out your business best practice. And as we'll get into again, we'll probably read it, and get with your insurance agents. Jeff pointed out about signage. None of the orders mandate signage, but your insurance carrier may want to see signage. And I certainly think it's a good idea. So with regard to the pools and the community room fitness center, 50% capacity is a big one, are still in place. Guests can now be allowed. Social distancing is required. With regard to facial coverings, the order is very specific with regard to facial coverings. All people visiting or using a common area of a multifamily housing development or residential facility, which includes reception area, hallways, elevators, and the like, community rooms, anything inside, must wear a facial covering, even when social distancing of 6 feet is being maintained. So inside the common amenities in an association, you are wearing facial coverings regardless of whether you're social distancing. That does not apply if you're with people of the same household, but that said, if you're in this and there's going to be other people around, if you're the only people in there, it's you and your family, I guess you can take your mask off. But if anybody else is in there, it's supposed to be on whether or not you're social distancing. As far as outside amenities, pool deck, etc., facial covering should be worn if you're not able to social distance. But if you are, then you don't need a facial covering if you're social distancing. Pool and pool deck is social distancing is required. If you can't do that, you should be wearing a facial covering.
And I want to add as well for Palm Beach County, so as to avoid any confusion. If you're outside and you cannot social distance, then you need to be wearing your face mask. But similar to Broward County, if you are inside, then you need to be you need to be wearing your face masks, just like Broward.
Regardless of whether you're social distancing or not.
Yeah.
So that's a believe it or not, Craig, that's a fairly quick summary of Broward. Broward has got the media stuff going on, but I hope that gives people general information. It's not legal advice, it's general information, like Craig pointed out. Miami-Dade is the county, for those listening from Miami, you're going to need to probably follow up specifically with your attorneys on specific questions, because Miami-Dade is the county that they issued their plan back in, I believe it was May, and it was this 100-page booklet which said this is going to be our reopening when we're in phase 1, when we're in phase 2, when we're in phase 3. Miami-Dade, to my knowledge, they are their facial mask requirements are similar to Broward County. And so the advice I just gave with Broward, you should be following in Miami-Dade. And with regard to the inside, you're wearing your facial coverings at all time. Outside, if you can't social distance. As far as the amenities can be open, but again, can be open with restrictions. One point that I want to point out. The facial coverings in Broward County, and I don't know that Miami-Dade has the same, but in Broward County, in gyms, if you are actively exercising, the order says you don't have to have your face mask on. So what it's saying is when you walk into that gym, when you are walking between equipments, machines, when you are in between exercises, your mask should be covering your nose and mouth. If you want to lower it down when you're in the middle of an exercise, that is okay. I don't necessarily agree with it. I think that's when you're breathing everything out. But they're saying if you're actively exercising. So do know that is something the order says. Associations, you can restrict though. You can say, sorry, if you're working out in our facility, your mask is on at all times. Okay? But that's what the order says. Miami-Dade explained, and if I may, since we do have a lot of visitors from outside the Tri-County, in particular, I'm talking, Orlando North. This I think applies to Lee County as well. The orders never really restricted access as much as they did down in South Florida. There was a limitation on pools, is my understanding, which has been lifted for a while as far as the county goes. Associations have been left to determine what restrictions you want. Similar to what we talked about, you can be more restrictive, and you should be discussing this with your management team and your council to determine what best works for you. There's no one size fits all in any county, any city, even that you have to communicate on a case by case. The only orders that still remain in place in the rest of the state, or at least in these other counties, Hillsborough in particular, I believe in Lee, are mask orders are still in place. They have not been removed. So you still have your facial covering requirements, which I believe are similar to what we've already discussed. But check with your local county attorneys.
Thanks, Michael. Jeff, up in Palm Beach with no capacity restrictions, like around the pool by way of example, what's the limitation? Is it gathering rules? Is it social distancing rules? Like, what is the limitation in Palm Beach around activity at the pool?
It would be social distancing.
Social distancing. Yeah. Okay.
So you need to make sure you're 6 feet, and then however many people you could put there 6 feet apart safely.
Yeah. Good. Okay. Thank you. You know, guys, the one thing I will kind of throw you a bit of a curve here. The issue with respect to masks now brings up all the how do I enforce the mask regulations? Like, what tools do I have? And
Right.
the association, I think we've talked in the past, can fine, they can remove access, limit access to amenities and stuff like that, injunctive relief, arbitration, all those things. But the governor basically said you can enforce fines, but those aren't association fines.
Right.
Those are criminal fines, right?
Well, it's a great point, Craig. It's another issue, of course, a slight confusion. First of all, what associations should recognize is the governor's order said you cannot fine individuals. And I point that out because associations aren't in that order. So if code is still, like Jeff mentioned this, if association's not enforcing certain requirements that the county might have, for instance, facial coverings pretty much is the one they have, or for example, you open your pool in Broward and you're not enforcing 50% capacities and somebody calls it and the county comes out, the association can still be fined. It's only the governor said counties, you cannot fine and cite individuals. That said, I agree with you, Craig. I believe that has to do with the penalties that were set forth within county orders against individuals. If the association is adopting reasonable rules and regulations and owners are not following those rules and regulations, those are still subject to fines that, again, a proper process all in place, fining established, committee established. They can still fine, they can still suspend use rights, they can pursue injunctive relief if in speaking with their attorney if they believe that's the best use of resources. Absolutely. Jeff, you want to add?
Need to add a little to that as well, that when the governor put out his order 20-244 dealing with the fines and suspension, et cetera, it's very specific and it's very interesting because the order, consistent with Executive Order 2092, suspends the collection of fines. It didn't suspend the imposition of fining, which is just a point that Miami-Dade made, and that's where I picked this up, that they said, fine, we simply won't try to collect our fines while this order's in play. But I don't think they have any intention of ceasing to issue those fines.
Yeah, I did read that. That was interesting.
Yeah,
okay,
and Miami-Dade being the county that's hit the hardest, I think they've been very smart in taking an aggressive approach to making sure people are following these simple guidelines.
Yep.
Guys, let's look at where we were. I want to compare where we are with respect to amenity openings now with where we were a month ago. So, Nez, can you pull up the results for poll question number 2, which is if you live in an HOA, have you opened your pool? So, guys, that's about the same as what we saw with respect to pools. Gyms, about the same again, maybe a little higher for gyms now. And clubhouses still really not opening up. I think this is pretty fresh still, right? We're 1 week into it. We're going to ask a question later about are you kind of considering changing your use restrictions. Marinez, can you pull up what's going on in co-ops just to share with everybody, please?
Condos.
Number 3. So in co-ops, guys, pools largely open, right? Gyms, 40%. We were last time, actually 40% not really right because there's 77 people there. So there's 60% gyms, which is about, we were 55% last go around. And common areas about the same. So not a bunch of movement in a month, not a bunch of movement appears as a result of the phase 3 stuff. And I know our associations are trying to figure it out. They're all calling their attorneys. What should we be doing? Any thoughts, guys, on those results?
Well,
No, I mean, it's been, I think actually, right. We met, it was, if we did that, was it a month ago or was that from 2 weeks ago?
Month ago.
Yeah. I mean, I'm surprised I'm surprised the gym, well, actually, I'm surprised the numbers haven't gone up a little bit, especially the community rooms, because people have been asking. I've even had some saying, hey, can we start renting them out again?
Yeah. Yeah.
And
Okay.
it's time to start opening the amenities. It's time to start opening the buildings. I think we're in phase 3 now. The limitations are certainly a whole lot less than they were before. So if associations in the past had said no guests can come in the building or contractors and various limitations, I think it begins to become a little more unwieldy for the association to defend that point of view unless they have a specific COVID outbreak, God forbid, in that particular location. But short of that, folks have a right to their amenities. Folks have a right to have their contractors come back in these buildings, but I think we can craft safety protocols to go along with that. So it doesn't happen in a vacuum, but it does become more difficult for associations to say, no, you can't bring your guest. No, you can't bring your contractor in when we're in a phase 3 reopening. Mike, what do you think about that?
I mean, earlier, I thought what you said earlier when you said, listen, if you can't do a certain thing, then don't open. Is something to keep in mind. I don't disagree with what you're saying now that the governor pushed to phase 3. Craig, you opened up with that, especially here in South Florida. I don't even know how long we were in phase 2. And these requirements were supposed to keep a positivity rate 14 consecutive days. Maybe I don't know. I know that there's been numbers up and down. This whole thing is bizarre. But I think that the answer here is you should be communicating more with your management teams and with your council about how you can go about reopening. The question isn't, hey, can we stay closed? Is how can we reopen and get a level of comfort that you can, even minimally. I had some clients I work with who said, hey, we're going to start with pools. We're going to open pools up maybe 3 days a week. We're going to allow contractors in, maybe, essential contractors. Like we had one community where they said, we have an owner who bought the unit. They can't live in it unless they can get this contractor in. Okay, that's different than someone who wants to have a contractor in to do some cosmetic work. So, I mean, there's certain things you can consider. There's a lot of time. This goes back to it's not a one size fits all. You need to address things case by case. And there are ways to safely be allowed to move forward with reopening if there are not factors that would consider you would want to keep it closed, depending on who makes up your community. Do you have outbreaks, things of that nature? It's a lot to think about.
It does lead. I want, Marinez, if you could post poll question number 4, with the move to phase 3, are you reconsidering your rules regarding amenity usage opening? And I think, guys, this is going to be interesting to see what everybody says here. But the reality is the governor, basically said we're back in business. The local municipalities have relaxed their rules, provided some clarity in Broward's standpoint, but really relaxed the rules. The associations have had their own set of rules with respect to amenities. You can still, we talked about this in webinars before, you can still stay closed. That is your decision. It becomes harder and harder, I think, as the pressure of the boards picks up, and I've asked that question as well. So we'll come back to that. But Jeff, question for you, 2-part, and you started to talk about it a little bit. Can an association still adopt stronger restrictions than provided in the county orders, number 1? And 2, for those communities that still have their amenities closed, is there an increased risk of litigation now if they keep them closed now that the restrictions have been eased?
Well, I think there is increased liability, again, if you don't have the good justification for keeping the amenities closed. So we need to bear that in mind. But if an association has reason to close their amenities, if they have reason to prohibit individuals, just create a good record. Be in touch with the association's lawyer. Don't make decisions in a vacuum. Can you be more restrictive? You bet you can be more restrictive. The associations can adopt rules and regulations to make sure that folks are wearing face masks when they're in the building, and you can have heightened contractor rules if you want to require gloves for one reason or another. Right now, there's little things you could do maybe that would make the situation a little bit safer as we go through. But again, do discuss those items with the association's lawyer.
Michael, for you, if you look at it the other way, under what circumstances can an association continue to shut things down? And Jeff, I think you touched on it, which is kind of you have to have now. You were just allowed before because of risk. Has it changed, Michael? Do you need to have, is it best practice? Do you need to have a good business case for keeping it shut?
Yeah, the situation hasn't really, the responses haven't really changed that much over the last couple of months. The fact that we went from phase 1 to 2 to 3 real rapidly, the situation remains the same, in my opinion. It's that you need to be able to open up comfortably. Now, the orders, you can't rely on the orders as much as you could before because the orders have now been pared down. In particular, like we talked about in Palm Beach in particular. In Broward, it requires the capacity limits, and Miami-Dade has similar. If you, like the Broward order says, if you cannot meet the requirements, the minimum requirements of this order, you don't need to open. That said, those minimum requirements have been raised somewhat, and you really need to ascertain why is it that we can't meet these requirements, and can we do so safely? And I know we've mentioned this multiple times, and it's not self-serving, guys. Speak to your association attorney. If it's us, great, get with us. If it's someone else, get with them. But on your management team, of course, but let's not forget, bring your insurance agent and your underwriter into this picture. Because now you want to start opening up. We talked about what if you were facing action for keeping closed. If someone said breach of fiduciary duty by not allowing me in, you have coverage in place for that. Where you may not be out of luck with coverage is if you open up, you're not following, and someone claims they got sick because you did and didn't follow the requirements. That still remains a concern. So bring your agent into this and make sure that you're able to comfortably do what you need to do. But I do think you want to start looking toward how can we reopen rather than how can we stay closed.
I think that's a good frame, and that's what we're hearing from our clients, and it begs up, the next issue, which is really now, okay, how do we, under what circumstances do we open? What are the rules in place? We've been shut. We haven't had to deal with, extra cleaning and stuff like that, which I want to get into next. But Marinez, let's post the results of the question number 4. So with a move to phase 3, are you reconsidering the restrictions you have placed on the uses of amenities? So guys, as expected, more than half of our communities are right now. And I think if you combine that has there been an uptick in pressure from your community to revisit the opening of amenities or their use restrictions? 70% saying yes. So the inmates are starting to rattle the cages.
Yep.
So to speak, which I think makes sense, right? Like there is this perception that it's not going to be business as usual, but we're heading back to normal. So I want to go off script a little bit here and talk about opening of amenities. And Jeff, you talked about the requirement for enhanced cleaning.
Right.
And I think it's a good practice, not only a good practice, but it's in the order in Palm Beach. So
Correct.
Can you give us some comments on that, if you don't mind?
Sure. We go to the CDC for guidance, and there's really 3 publications that I'm sure you'll have on your website. One is titled Reopening Guidance for Cleaning and Disinfecting Public Spaces, Workplaces, Businesses, Schools, Homes, Cleaning and Disinfecting Guidance. Another one is Guidance for Administrators in Parks and Recreational Facilities. And a third one, Consideration for Pools, Public Pools, Hot Tubs, Water, Playgrounds. And really what they're talking about in each of these orders is, using a disinfectant that's been approved by the EPA, a normal routine cleaning will decrease how much of the virus is left on surfaces. And they're talking about develop your plan, implement your plan, and maintain and revise your plan to the situation as changes are needed. They don't tell you specifically you need to do this every 30 minutes or every 2 hours. We know that enhanced cleaning protocols are more than what you're doing now. So we can clearly go there. But I think we'll always have a gray line as to whether an activity constituted that enhanced cleaning responsibility, if in fact it's not patently clear on its face that was an enhanced protocol. Then you can get into questions, well, was cleaning the bathroom twice a day instead of once a day, was that really sufficient in light of the COVID-19 breakout? And that's an individual question, I think, that has to be analyzed by each business owner, each association board as we go through this.
One of the challenges we had from our associations that have been listening in is they just didn't have the capacity to do any cleaning, so they were closing their pools. You still have that potential risk, right? Like if you can't do cleaning or enhanced cleaning.
If you can't do enhanced cleaning, if you can't ensure people are wearing their face masks, then I think that the association is well on its way to justifying why they may not be opening a particular amenity.
Although then right, and I agree, and also why are you unable to do those things?
Could be budget.
What is the reason for it? Because the situation may be, hey, listen, we can do that, but it's going to require everybody to pay an additional X number of dollars because we don't have that in our budget. Right. So these are the things that this goes to, hey, let's look at how we can reopen rather than let's keep closed. That said, case by case, and some communities, especially maybe a smaller community that doesn't have the staff or the resources to open, might keep it closed for that reason.
I think from our standpoint, as you move to reopening, you have more risk. I think the issue becomes risk for the association, right? To your point before, you don't really have insurance, especially don't have insurance if you're negligent, especially, you just went from monitoring the pool to maybe you don't have to anymore, but is it still a best practice so that you can demonstrate if someone gets sick and they try and blame you? Yes, we're still monitoring, yes, we did enhanced cleaning, someone's got to look after the social distancing and the enforcement of the regulation. So I think that, the risk is increasing. Do you agree?
Well, the risk increase there was less risk if you were closed, of course. So yeah, if you open, the risk is there's an increase in risk. It's a matter of how you are addressing that risk. Right. It goes back to having signage in place. Yeah. Have those sanitization stations. And I think that is a minimal cost. Have those around and put out a notice to all owners that the pool's open, whatever, that these are the requirements. And while the association will do its part, you are responsible to do your part, and you are assuming the risk. And put all that in play. But then you absolutely, if we're speaking pools specifically, you absolutely have to have the ability to go by there periodically. I don't know if that means once an hour. I had one community that said we have 3 people at the pool all day. In that instance, an 8-hour day, you probably don't need to clean once an hour. But so that's why I say it's a case by case. If you can see how many people are actually going to the pool or multiple pools, you have to have the ability to clean and sanitize the areas on a regular basis and document you're doing that, so that if a claim does come up, Craig, like you just mentioned, you have the ability to defend yourselves and from a case, and whether it's out of pocket or whether you get that gap, legal defense insurance, if your regular coverage won't offer.
Guys, I wanted to go back to, again, on the reopening, and I forgot to ask the question before, and it comes up mostly in Palm Beach, Jeff, but, tennis, bocce, volleyball, outdoor sports, if you're going to start to open up your amenities, outdoors seems to make more sense than indoors at this point. But are there anything, there were rules around monitoring tennis, I know, are those all gone now?
Sure. Remember that the newest Palm Beach County order repealed all prior orders except for the face mask order, and it still requires social distancing. If you're going to be playing contact sports, if you're going to be within the 6 feet of social distancing, then you're wearing a mask.
Okay. Michael, anything? Same.
I know. I think that I think it's the same. There has been nothing that I can recall specifically, certainly about the amenities in an association with regard to tennis courts, etc. So I think that you're wearing your facial coverings on your way out. You should be social distancing unless it's a member of your own family. And then obviously, if you're for tennis, for example, when you're actively playing, you don't have to have your mask on. But under the new order. But as soon as you stop playing, and you should have the mask.
So guys, we're getting a bunch of questions as we're talking about the reopening of amenities and revisiting some of the skeletons in our closet from before. But I'm seeing a couple of questions on, now that we're opening up, should we have residents or guests sign hold harmless agreements? We've talked about this before, but can you just give me your quick guidance on whether or not you think those are effective and really a necessary step in the process? Are you recommending it to your clients?
Jeff?
I'm not recommending them to my clients per se. When we do discuss, it's a matter of whether or not first, is there authority to require a hold harmless before you can use the amenities in the declaration? If it is, then you're on solid legal ground to make the request that an individual sign the hold harmless prior to using the amenity. Absent that, the owner could easily turn around and say, listen, I have a use right to this amenity. There's no restriction on that use right. So if it's open, I have a right to use it. You can't make me sign a hold harmless before you let me use it. And I think that logic does make sense. On the other hand, it never hurts to ask. And maybe it helps, but it's really not a solid shield as you might think of a hold harmless, because it's rather self-serving and one-sided, and the courts have a tendency to disdain that type of hold harmless. Mike?
That's perfectly said.
There you go.
don't sign a hold harmless and I won't clean the pool because you held me harmless. It's all at my risk. That's not gonna win you any battles. It sounds.
And the only thing, and remember too, a hold harmless, a waiver, you can't waive your own negligence. So even if somebody signed it, if you're negligent, if the association's negligent, the fact that they signed a waiver hold harmless doesn't insulate the association in any way.
Yeah, great point. Guys, so let's put a pin in this discussion on the amenities. I think if I can just summarize from what I understand, our communities are getting more pressure from the residents to start to open, which makes sense. Have a plan, have it approved by your attorney, which we've said, as long as you adopt these new rules, use rules and regulations, you need to communicate them. You need to get your attorney to sign off on them. There are nuances still in the orders. We're spending a lot of time with our clients communicating. I think it's number one right now. If you're staying closed, why are you staying closed? Don't just stay closed. Let the residents know. This is why. We're worried. We can't afford it. We can't find anybody to do it. All those types of things. If we're opening, really communicate kind of the soft start, if you will, which is what we're recommending to our clients. A soft start. Make sure everything outdoors is kind of your first focus. Inside, maybe not. We got a bunch of questions on, meetings now. We talked a lot in the past about Zoom meetings when everybody was social distancing and the clubhouses were closed. With them starting to open right now, what are you recommending your clients do with respect to in-person meetings now? Michael?
As far as I don't recommend they have in-person meetings. The question is really more along the lines, are we permitted to have in-person meetings? If they ask it that way, I said, well, there's nothing that bars it. You just need to make sure if it's indoors, you have to make sure you can social distance and that everybody wears facial mask covering over their nose and mouth. If you want to have an in-person meeting, my recommendation would be if you can hold it outdoors, in a way that everybody can still social distance and should still be wearing their masks, but it's obviously a safer environment to do so.
Good stuff. Jeff, anything?
I was just thinking that, you think I would know better, being a community association lawyer for over 20 years now, being on the board of my HOA for the last 8 years. And we went to the Zoom platform and we provide an opportunity for all of our members to join us on that Zoom platform. We provide the opportunity for all the members to address the board and have actual comments, not type their questions in, but actually address like we're talking right now.
Yes.
And we have found that over the last several meetings, we have been far more efficient in getting the business of the association concluded through that platform. So I'm not in a hurry really to want to run back to the live meeting platform to begin with.
Yeah, Jeff, I think it's a great point. We've experienced exactly the same.
In person, I guess.
Greater participation.
Right.
More cordial. I don't know whether people don't want to scream into their computer, but way more cordial. Meetings are faster. So I'm with you. Like, why run back to the clubhouse? And if you've got the technology sorted out. So we're seeing a lot of that as well. And my guess is, there'll be some Michael on the legislative front. There'll be something around. There'll be some contact.
Well, Craig, it's funny you mentioned that. I'm writing an article right now. We should have it ready in about 2 weeks or so that will address the association's ability to continue using electronic meeting platforms when the emergency orders are no longer in play. And there is a balance to be undertaken. I'm not going to go into a whole lot of detail right now, but pay attention to Rembaum's Association Roundup. If you get the Florida Community Association Managers Journal, the article will be in there as well. I would like to see
a little teaser.
By the way, I wish you'd write faster because we're getting the questions now. So just.
Well, listen, we don't have to worry about it now because the emergency order is still in play. Virtual meetings are absolutely acceptable. They will be acceptable after that. I don't want to give anything from Jeff's article away, though.
No, go for it, man.
But I think that the most important point that you guys touched upon too is if you're doing these virtual meetings, members are allowed to attend and members are allowed to speak. And in my opinion, and Jeff also just addressed this as well, speaking doesn't mean that they type their questions or their thoughts into a chat space.
Correct.
I just had one meeting and everybody, the meeting comes on, the host can mute everyone. But then when we got to a point where they had a motion, a second, any board discussion. Okay, are there any owners who have a question, comment, etc.? And there's a monitor. There was one of the owners who's the IT guy. Okay, anybody who's got a hand raised, and if they can't raise their hand, they can type in "I'd like to speak" or something like that, and give a minute or two for someone to raise a hand, if you will, under the app. that's important that they have that opportunity. I think, to your point, Craig, that open line of communication. And I applaud you for even opening with that, because that's something that we emphasize in forever. Communication with your membership is the key to having a successful community and keeping things, relatively calm. And owners being allowed to, if they want to get on and vent, they have the right to get on and vent. They get their 2 minutes, but that's important even in the Zoom feature.
It is important in that it's just you don't collapse any of the other rules with respect to association meeting. Right. It's just a different platform, and Zoom's done a wonderful job. I see a question: are there other platforms? There are. It's funny. Zoom now is not only a brand; it's
like Kleenex.
Exactly.
Right.
The purpose of the brand, it's Kleenex. So
or Airbnb.
A verb and a noun all rolled into one.
Right. So there are other platforms, but I've not been on any. I've done like a closed meeting, like a client did a closed meeting with me, but only the big meetings have all been through Zoom to this point for me.
The Microsoft platform, I have experience with that one, and that was interesting.
There are a couple Zoom teams. We've kind of found comfort around Zoom, and I think as you use it more, you get more features. And I saw a question about cost. It's really not that expensive. There is a free version. I think it limits the number of people, but
and I think you can only go 40 minutes.
Yeah, that's the kicker.
That's perfect.
But for $16 a month, you can have unlimited usage of Zoom and up to 100 people for as long as you'd like in the meeting. So that's going to help a lot of associations, right?
The smaller ones, because if you're a community like my community, we have 1,150 homes. You're lucky to get 20 people at a meeting, but you can't limit it to 100. You have to be able to allow more people should they decide to come in. So you need to have the option that's a little more expensive.
But it's not going to break your budget for sure.
No.
That's the issue. Because you have a couple of minutes, I wanted just to talk about non-essential visitors. I wanted to check in on where we are with respect to whether people are allowing them. Most were the last time we checked in. The real question now is, have you adopted new rules and regulations and procedures relative to your non-essential visitors? So, Nez, can you post a poll question number 5? If permitting non-essential visitors, have you adopted any additional rules? Michael, what are your associations doing? What are your clients doing?
They are definitely the debate. Well, to some surprise to me, there's a lot more of my clients than I was aware of that had been allowing contractors and guests in as of late. But definitely with restrictions. The questions I've had from clients saying, "Hey, we're considering this," or like I pointed out, there was a couple of communities that said, "We have some owners who purchase units. They need work done in order to actually be able to live in their units." And my thought on that is those are somewhat essential contractors, and that you can definitely establish reasonable rules and regulations, restrictions, if you will, on allowing them in, but it does make sense to allow them in. It is in line with the phase 3 objective of opening up businesses and allowing the economy to flow, even though it is focused more to the for-profit outside, these contractors being able to conduct their business by getting in and doing their work. That is in conjunction with what the phase 3 is. That said, you need to be able to feel comfortable that it can be done that way, and your owners need to acknowledge and accept that it's not just a free-for-all. The bottom line is, even prior to COVID and post-COVID, you might have it, especially like in condos with the elevators. You have to schedule the elevator. You have to make sure you have the elevator, carpet, the elevator coverings, and have your deposit in place. All of those things still need to be followed, but you should have, I think, additional restrictions, limiting maybe the number of people who can come in at one time, contractors can come in, having them gloved, having the elevators, sanitized after they leave, making sure they don't congregate anywhere but your unit, things like that.
Jeff, anything? You're the same ideas?
Exactly the same ideas.
Yeah.
Craig, while we're waiting on that poll, if I could just point out one thing you mentioned earlier about rules, and this came up a couple of times with me, and I want to just remind everyone. I had a board say, "Hey, because the county says this, can we just follow that, or do we have to have our own rules in place?" Have your own rules in place. You need to be adopting rules properly, and if you're addressing rules governing common areas, common amenities, 48-hour notice. Any rules that impact use of the unit or the lot, 14-day notice. and that needs to be mailed and posted on the 14 days. So get with your council and make sure you're doing these right, but have these rules properly adopted, then published to the membership so that they are enforceable should you need to enforce them.
And Mike, I want to emphasize, because you just raised this point, and it was a really good point. You need to be adopting these rules correctly if you have any hope of enforcement later down the line. It was one thing when COVID first hit and associations and these emergency orders came out and boards were coming out with their own rules regarding maybe no outside realtors in the building or outside contractors, and things went into play the very next day. Well, now we're in phase 3. It's time to, if you haven't properly adopted the rules or you needed to change them, then like Mike said, 48 hours or 14 days, depending on the type of rule you're adopting. But you absolutely want to position your association in the best possible light for enforcement abilities. And if you don't adopt those rules, then I'm afraid your lawyers are going to be not very useful to you down the line, because it's all going to come back to whether the rules were properly enforced in the first place.
Right.
Or properly adopted in the first place.
Right.
Guys, Marinus, can you share the results of if you're allowing contractors working your, so,
Wow.
temperature check was a big issue back in the day. Doesn't seem like very many people are doing that. Mask and or glove requirement. I think if I just heard you guys properly, if you're working inside the common area, you have to wear a mask, right?
Right.
Didn't you just tell me that?
Well, right. The contractors are going to a unit, but when they're walking through the building, they're mandated to wear a mask, as are the owners who are meeting their contractors. So those 21 of you who aren't, make sure you are.
And then limiting the number of visitors. So still some rules, which is good. Look at the few people they've
Hold harmless.
on the hold harmless, which
Yeah.
is what we talked about a little bit.
Have you, but just about contractors, how does that apply to the realtors? Like, I had a question come up saying, hey, a realtor reached out, said they wanted to hold an open house. And I know that's something that we had talked about, open houses you're not doing. And in my opinion, I don't believe that phase 3 should be changing that necessarily to an association. If an open house is a free-for-all. I think that they can allow realtors to show these units, but I do think you need to be adopting reasonable rules and regulations. Again, adopt them properly, as we talked about, and that is regarding use of the unit.
Mm-hmm.
And that means you got to do a 14-day notice that you're posting and mailing.
Mike, open house by appointment only.
Right.
I'd be okay with that.
Right. By appointment only, and again, limiting the number of people that you're showing at each appointment.
Right.
And masks, of course, mandated.
Well, guys, there's a question. It's a good one. It just speaks to the 14-day notice and the properly adopting, rules. If you're changing your rules, it's the same thing.
Correct.
14-day notice. Here's the new rule. Have the meeting.
It's 14-day notice, again, only if it's use of the unit or parcel. Like, for instance, if you're going to limit someone showing their unit, that's unit use. If you're saying we're going to limit the gym, that's 48-hour notice.
Okay.
That's just posted. The 48-hour notice is posted where you normally post. The 14-day notice is posted and mailed 14 days in advance.
To all owners.
With affidavit of mailing, document it like Jeff said so you can enforce it.
Yeah, what I would say to to the board's members listening, don't guess. Get with your attorney. You want to do this properly because this is going to give you the teeth to be able to enforce later. Because if it's not adopted properly, basically you have at the end of the day, you have no right to enforce it.
That's a smart use of your resources. That's why you have a line item in your budget for legal.
And there's a case out there when you're in the courtroom and things are happening and the defendant says, you know what, judge, they didn't adopt that rule correctly. It's incumbent upon the association then to show it was. And one of the things a good association litigator does is they'll never take one of those cases into court unless they have a notebook. And in that notebook is going to be the minutes from the proper rule adoption, the affidavit of mailing, as Michael alluded to. It's all going to be there so that the lawyer for the association say, hey, wait a minute, it was done right.
Right. Guys, we created a little confusion around Zoom meetings. The issue with respect to meetings, you can still go the old-fashioned phone route, right? Everybody has to be able to hear. Is that what I understand?
Sure.
And participate, but you don't have to use a Zoom. You don't have to be able to see you. It doesn't have to be.
No.
platform. It could be an old-fashioned conference call. Is that?
It sure can. And in fact, you can, call in to Zoom. That would have been my last resort if I couldn't get back online after we had lost the power, would have been simply to pick up the phone and call in. So Zoom does
So I
allow
use
for
it as a
that.
conference line, not a video line.
Right.
So that can be used.
But anyway, you can always do, board meetings can be held via conference call. And Greg, and just so you're aware, like and I just said this to a board member yesterday, they were in an office and I said, hey, President, if you were sitting in this clubhouse and you had a speakerphone and you noticed a meeting that the location was the clubhouse, social distancing and masks, all the other board members could call into the speakerphone. You don't need to give the owners that conference call number for that board meeting because there's a physical location where they could come and attend if they want. But if you're doing the meeting all by conference call or all by Zoom, that's where you have to give the owners the same ability to join.
And I think you'd be wise to always, if you want to try to have your meetings via Zoom for board meeting, member meetings, condo, HOA, and not run afoul of any of the legislation, then you'll always arrange for a location, a hard location where there's either a speakerphone or a computer with the Zoom meeting, one or the other, speakerphone or computer, so people have a way to listen and or watch as the case may be. But if you hit both of those, then you're probably going to be compliant with all of the legislation that's presently in existence now, and that's how you can continue to use your Zoom platform. I'm not saying that you have to sort of extrapolate through all the different statutes, but if you simply have a physical location where those members that don't have the ability to call in or don't want to, and you notice that it's going to be in the clubhouse or it's going to be wherever that location is, then you're good to go.
Excellent. Well, guys, that not only concludes this episode, but season 1 of our webinar series. So we will start season 2. We've been picked up for season 2. Netflix is going to be renewing.
No cliffhangers? We're not going to leave a cliffhanger for season 2? Well, it's probably the whole summer?
No, Jeff's article on Zoom meetings. That's the cliffhanger.
There it is.
Right.
In 2 weeks. So we are going to go move on to another set of webinars, really discussing the things we've really moved to over the last little while, which is issues affecting leadership, leadership support in communities. That starts in a couple of weeks. So look for the invitations. We really appreciate all that you do. All the board members out there are working hard as usual, making tough decisions as usual. Jeff and Michael, your advice is much appreciated, and I appreciate you joining me this afternoon. So thank you very much.
Same here. Thank you. Stay well, everybody. Good to see everyone.
See you in a couple of weeks. Take care.
Bye-bye.
Bye-bye.